Carlson v. Colangelo.
May it please the Court, Irma Nimitz on behalf of Plaintiff Appellant Christine Carlson. I respectfully request 3 minutes for rebuttal, Your Honor.
Yes, of course.
Thank you. Under the public policy of this state, interim clauses are disfavored and must be strictly construed. Here, we respectfully request that this Court reverse the Second Department decision granting summary judgment to defendants' respondents. In this case, Chrissy Colangelo, who was a trustee and also a beneficiary of the Donald P. Dempsey Revocable Trust, used an interim clause as a sword to bully the only other beneficiary of the trust, Christine Carlson, into accepting only one of the pre-residuary bequests that the decedent wished for her to have, and as
why is it Ms. Carlson's action doesn't challenge the trust or the will? Why is it it's not in violation of the interim clause? Put aside whatever you may be arguing is potentially misconduct by the trustee.
Let me address it this way. In matter of Singer, this honorable court said that interim clauses are to be construed narrowly, and surrogates should then, or judges of the Supreme Court, should look at on a case-by-case basis the conduct of the beneficiary. Here, Christine Carlson, and Your Honor, I submit that you have to look at her conduct not in a vacuum, but as a result of the trustee's conduct. But what did Christine Carlson do? What she did was try to effectuate the intent of the decedent in giving her two pre-residuary bequests.
Counsel, was she entitled to $350,000?
Yes, she was.
I thought the terms of the trust were, if it's possible, or it's my sincere wish, or something like that.
Your Honor, I'm glad you pointed that out. Defendants' respondents at the outset said that the trust provided that that language was precatory, that it was decedent's wish and desire for Christine Carlson.
So she asked for $350,000 minimum, right?
Well, the trust actually provided it was up to $350,000.
Right, but your client, in bringing this suit, asked for $350,000.
Yes, which is
So
what
how
the
is that not
decedent. Well,
contradictory?
Your Honor, you have to look in addition to the trust to the will of the decedent. This was a pour-over will into the trust. Typically, a pour-over will mirrors the language of the trust. This was sloppy drafting, but if you look at the will, it says that the decedent directed the trustee to give Christine Carlson $350,000 when the property known as Dempsico was sold. So there was a clear direction to distribute $350,000
Well, when you say sloppy drafting, does that at least create an issue about what the decedent's intent was?
I don't believe so, Your Honor. When I actually meant sloppy drafting, I meant that the attorney drafter spelled her own client's name wrong. It's Chrissy without an H. I meant that the provisions in the will do not mirror the trust, but the trust controls.
Well, but that sounds
there was no question.
a little sloppy, no? The provisions in the trust and will say something slightly different about that $350,000?
Yes, but the trust controls. That's,
So if the trust controls, the trust language is clear, and you're not entitled to $350,000.
Your Honor, I respectfully disagree. I don't know how we're not entitled to $350,000 when it's
trust
specific.
control, and you're saying we should look at the will?
To determine perhaps the decedent's intent, that it was a clear direction. And indeed, the defendants, after their motion to dismiss, the complaint was denied, they gave up on that language that it was precatory. There was never a suggestion that Christine Carlson was not entitled to the $350,000. But let me address Judge Rivera's initial point, which was by bringing this lawsuit, was Christine Carlson, did she violate an interim clause? And our position is no. She brought this lawsuit to enforce the decedent's intentions, which was that she was to receive two pre-residuary bequests, the house where she and the decedent were living and
Well,
$350,000.
If it were simple enough to avoid an interim clause by saying, all I'm trying to do is effectuate the decedent's intent, and, for example, the decedent actually didn't mean to put this provision in the will, or didn't mean that it should be interpreted this way, I'm not sure what interim clause would ever be effective. The decedent didn't actually mean to sign this will. That wasn't his intent.
But, Your Honor, the decedent did sign this trust
In this
agreement.
particular case, I'm talking about the rule that you're asking for, which sounded as if you were saying, if what someone complaining about is that some provision in a will or in a trust instrument doesn't actually effectuate the decedent's intent, I don't know why you couldn't always say that when you were challenging some provision of a will or a trust.
Your Honor, we did not challenge any provision of this trust. We simply sought to enforce it.
What
And there are-
about the interest in Demsico? The 50% she asked for?
Yes, Your Honor. We believe that that also did not seek to keep in mind, interim clauses are for distributees of the decedent seeking to set aside a trust. Christine Carlson was not a distributee of the decedent. Indeed, the decedent was never married, had no children.
Sorry, can you finish your first thought in response to Judge Troutman's question? Because I did understand that the trust required that the ownership interest be transferred in toto to Colangelo. And
I agree with you.
Carlson attempted to stop that from happening.
Your Honor, I disagree. Christine Carlson, from the outset, never contested that. What does the trust specifically say? It says, this grantor's interest in Demsico, or the trust's interest. It doesn't say that this grantor has a 100% ownership
Going to
interest.
the chief judge's question he just asked you,
Yes.
couldn't you always say that? I leave you my car, but you don't really own that car. I'm not challenging that you left this person the car, I'm just challenging you don't have an interest in the car. It's just one way of challenging it that you'd hope won't trigger an interim clause, right?
I don't think so, Your Honor. Here, there was no evidence that Donald Dempsey owned Demsico 100%.
But that goes to the merits, I think, of the argument you're making. I think some of the questions you're getting, and I would try posing it to you again, is, is it your argument that if you characterize it, which it sounds to me like you're doing, as enforcing the decedent's intentions, it can't trigger an interim clause? And if that's your view, then what's left of the teeth in an interim clause? That's what I'm trying to understand.
So an interim clause is meant to discourage distributees of the decedent, of which Christine Carlson is not. A distributee is an intestate distributee.
So is your view
So-
that she's not bound by the interim clause has no effect as to her at all because she's not a distributee?
Well, I think in this case, it's illegal. She was not able to set aside this trust. But what would she have gained if she set aside the trust? How do people set aside a trust or object to a will?
Well, it's not necessarily setting aside the trust, it's what you think the trust means, and you may and then be challenging exactly what the decedent wanted. I know you're characterizing it as simply trying to effectuate the decedent's desires, but let me ask you a different question. Let's say we disagree with you. What would have been her recourse? If her understanding is, no, the decedent is, forget the $350,000 right now, definitely wanted me to have this house. That's clear from the will, that's clear from the trust. The trustee is not turning it over to me or demands that I sign some document, and I think that's unlawful. What would have been her recourse? Other than the action that she took, is there any other
That's an
recourse?
excellent question. What does a beneficiary in this situation do when she...
Couldn't go to surrogate's court?
We could have gone to surrogate's court. However, Demsico, you cannot bring an action with Demsico. It's not a decedent, that would have had to have been in
Couldn't
Supreme
you go
Court.
to surrogate's court to enforce the trust, the terms of the trust, or no?
with the exception of Demsico, because it was just with respect to decedents. But may I answer Judge Rivera's question first, and that is, what was she to do when a trustee violates her duty of loyalty, when a trustee conditions a bequest on giving up 50% of your bequest? So the trustee on her own violated her duty of loyalty by
Can't you
giving...
make that argument? Couldn't one make that argument in a wide range of circumstances? I think what you're hearing us grappling with is what remains of an interim clause if one could make allegations along these lines in a wide range of cases and therefore subvert the purpose of an interim clause.
What remains is if a distributee contests what's in the trust or will, then perhaps they violate an interim clause. But interim clauses in and of themselves are meant for distributees next of kin of the decedent
But
who
this
seek
says
to set
beneficiary.
aside, excuse
Doesn't
me?
this say beneficiary, this?
Yes, but in the case of a beneficiary, it would only be a beneficiary who gained more from a prior instrument. That did not occur in this case.
So could you have gone to surrogate's court and said, what the trustee is doing here is inappropriate, conditioning my getting the house on anything else, period?
Your Honor,
And gotten an order from surrogate's court saying she's got to distribute the house, and Demsico stuff is not my business, but she's got to distribute the house.
well, in this case, we vehemently argued to the Supreme Court
Yeah,
and to
my-
the appellate division.
My question is different. Could you have gone to surrogate's court for that relief?
We believe that in that case as well, the trustee sought to frustrate Christine Carlson's bequests at every turn in terms of discovery and in terms of, I'm sure she would have also brought a proceeding in surrogate's court saying that Christine Carlson violated the interim clause. But in the 1 minute I have left, I must bring to your attention that a trustee
No,
has
just to
fidu-
clarify this point, you're saying, I don't know that you would agree, but you're saying that the same argument that trustee is making here, they would have made if you had gone to surrogate's court?
Correct.
Because it's the same, the challenge, the nature of the challenge is the same? Is this your argument?
Yes, and I'll just say, I know the red light is on.
That's right, take your minute.
I would
Yep.
just say that courts have to look at a trustee's violation of her fiduciary duty. It wasn't just, Christine Carlson, give up 50% of your bequest and sign a receipt and release agreement. It was an indemnity agreement indemnifying the trustee from any and all claims brought by anyone. So if the decedent's estranged brother in Florida sued Chrissy Colangelo, she would have asked Christine Carlson to indemnify her and release her from any liability. And I will say that the public policy in cases clearly state that any action or a precondition by a trustee upon a beneficiary is against public policy and EPTL 11-1.7. Thank you, Your Honor.
Thank you.
May it please the court, Michael Conacoff for the respondents.
Counsel, could you pick up with this last point on surrogate's court? Was there a remedy in surrogate's court here?
Your Honor, I believe that she could have brought a proceeding to enforce the proceedings of the trust, if that's what she was looking to do, but this
I'm
action,
sorry, to enforce the what?
to enforce the provisions under the trust, I apologize.
Including with respect to Demseco, I think she thought not.
No, with respect to Demsico, it was clear that Christine Carlson had zero interest in Demsico.
Right, I believe that's the merits, though. Could she have, whatever the merits are of the claim, could she have gone to surrogate's court to press her argument about the ownership interest in surrogates court?
I believe had she done that, we'd be in the same situation that we are today. I believe that would have triggered the interorum clause because
Well, I'm asking a different question. Is that something that surrogates court could entertain? Not how would it turn out or what would the impact be on the interim clause?
perhaps, Your Honor, I'm honestly not quite sure if they would entertain that.
So
Dempsey is-
suppose she actually owned 50% of Dempsey, just hypothetically, suppose she did that. What then would be her remedy? Where could she go?
Well, she wouldn't need to go anywhere. The terms of the trust state that the grantor's interest in Dempsico go to Chrissy Colangelo. That's it. So if she owned,
But my hypothetical is, and what if the trustee isn't recognizing that? That is, she actually owns 50%, the trustee is saying, no, you don't. What's her remedy? Where does she go? Surrogates court, Supreme Court, nowhere?
I think she could probably go to Supreme Court as she did here. However,
And why
what she was
wouldn't that
doing,
trigger the interorum clause?
because she wasn't a 50% owner. And I think we need
So whether
to.
it triggers the interorum clause depends on whether she wins or loses?
Well, I do think it depends on the merit of the claim, because here, for
Does it
example,
clearly
that's a tough
indicate what the amount was, the percentage? Does the trust clearly indicate he owned 100%?
the trust does not indicate a percentage. No, it does not.
Well, it
However,
says
the
it's
claim,
his interest. He cannot transfer more than his own interest.
it's the grantor's interest in Dempsico goes to Chrissy Colangelo.
Whatever that
under
may
the
be.
trust. Correct.
50%, it's only 50%.
Correct. But this was not a situation where Christine Carlson owned 30% and was trying to determine whether or not her 30% was maybe a 50% ownership interest. This was a situation where she testified in a deposition that she had no interest.
I want to go back, if I can, to your answer to the chief judge. If the rule is that whether or not a challenge to an ownership interest violates the interim clause, if that depends on whether you win or lose, that's a really big gamble to take, because no matter how strong, I think, in any litigation, right, no matter how strong you think your position is, you know going into court that you could win or lose. There's no sure thing. And so if that's the rule, wouldn't that really chill enforcing what might be a very valid interest?
I have to go back to the merits of the claim.
No, I'm
because if-
asking you to set that aside. Just take this as a hypothetical, if you would, okay? As a general matter, if we're thinking broadly about what the rule is, right? What I heard you to say in response to the chief is that if you bring a challenge such as the one here with respect to who owns what percentage of Dempsico in Supreme Court, that whether that triggers the interim clause or not depends on whether you win or lose.
Well,
Is that your position?
well, it depends on the language of the trust. We have to look at
Okay,
everything, and
if
as it
you
matters.
have language such as what you have here, but your view is that it depends on whether you win or lose, is that right?
I believe, my view is that it depends on the merit of the claim.
Okay, so if that's correct, what about the calculus that you have to go through on the front end? You might think your claim is strong, and in fact, objectively, that might be the case, but you could still win or lose. So what effect does that have on your practical ability to enforce a right that you might actually have?
Well, I think if we look under the provisions of the EPTL and the SCPA, there are provisions that specifically provide for certain actions that can be taken, right, in terms of discovery, for example, or in a potential will contest, there's certain people that you can depose when you think potentially maybe there's an objection
In your view, those
here.
don't trigger the interim clause? Or
They
they
wouldn't.
do?
No, they wouldn't. They're under 3-3.5 and under the SCPA 1404, there are specific exclusions that would not trigger the interim clause. Here, however, this was a claim made where Christine Carlson had the knowledge that she was not a member of
Let me-
Dempsico. There was no K-1s produced in discovery.
Let me still move back to the.
apologize.
No, it's okay. Let me just want to make sure I understand this, because a typical situation, what you might have an interim clause take effect, is when somebody says, this will is actually not the valid will. It was, signed under duress, or it was, And there, at least as I understand it, the effect of the interim clause doesn't turn at all on whether you're right or wrong. It's there to prevent you from making any challenge, right or wrong. The merits don't have anything to do with it in the situation where you're saying this is an invalid will. Isn't that what an interim clause is supposed to do?
Well, in an interim clause, for example, and I'll use the example of a distributee under a will, okay? If you challenge the will, say, for example, hypothetically, saying that there was undue influence.
Or this is not the person's signature, it's a forgery.
Correct. It was improperly executed, undue execution, duress, those are typically the objections. And if you win that case, the will is then knocked out.
If there's an interim clause and you brought your challenge in violation?
If you challenge a will, right, and you convince a court that that will should not be admitted to probate, that document is knocked out. And the next step is it either goes to a prior will or the estate would be distributed by the rules of intestacy. So that's why I say the merits of the claim really do matter.
Yeah, but the
And-
merits you're describing are that the will itself is invalid, and therefore the interim clause cannot apply, right? That's what you're describing there.
Yeah, in that
A
situation. yes.
different claim is, I'm not challenging this will. I'm not saying they should have given me the house. I'm saying it says I should get the house. It says I should get some part of this company, and all I want is the court to recognize that when the trustee, in this example for the trust, is not doing so. The whole point of the interim clause is so that you never figure out whether or not that challenge is correct.
My position is, and our position on which the lower court and the appellate division agreed with, was she was seeking more.
I know, but okay. So your position is that she is doing more, just to be clear, she is doing more than simply going to a court and saying, please give effect to this trust,
Absolutely.
word for word.
Absolutely. She is seeking a claim, and she is
Is that true for the house?
No,
Okay,
No,
so
not-
why didn't the trustee turn over the house?
because we don't get to the house. If you look at the language of the trust, it's Article 6,
Yeah,
paragraph A.
Yes.
Starts with the intangible personal property going to Chrissy Colangelo.
yeah.
Paragraph B, right, after application of Article A,
Yeah.
Demsico goes to Chrissy. That's it.
Whatever interest he has. Yes.
Correct.
okay.
The
You still haven't
grantor
gotten
or
to
the
the house,
trustee.
I'm waiting for the house.
The house doesn't come until paragraph C, after application of A and
Okay,
B.
but she wants the house, she doesn't care about that other
She
stuff.
wants the house, she triggered the interim clause.
Well, one, she could have moved to get the house, but I just have a little trouble understanding how this trust works, right? And you were describing it. It seems to me, and I just don't know this, that under the flow of those paragraphs, this isn't an ongoing trust. It's just a distribution mechanism. Like, does the trust continue, or does, at some point, Demsico go to one party, personal tangible property goes to that party, and then the house goes, and the trust is done?
I believe you've described it correctly, that there is an order of operations, if you will, in Article 6, and upon distribution of those.
So let's say that happens. A, B, C, all the distributions are made. This is hypothetical. Assume she gets the house, tangible personal property goes to the other party, Demsico entire goes to the other party. Now there's a distribution. There's no trust left, is my reading of this thing. Why couldn't she challenge at that point, I have an interest in Demsico?
Meaning after,
The distribution.
hypothetically, after the distributions were made?
Yes.
Hypothetically, if she had challenged it after the bequests were made to,
There's no trust. I'm challenging a trust. You have Demsico. I own part of Demsico.
but then you're looking to still challenge a document
What
that
document?
you had previously, that was previously enforced?
But the trust is over.
Trust done.
Your Honor, my only response to that is that's not what happened here, and I understand it's a hypothetical. I absolutely.
One other question. There was some discussion about will versus trust and language on the 350. Could you address that?
Yeah, and counsel is correct that the language regarding the $350,000 is different in the trust and the will. And for the record, I didn't draft those documents, so. But with regard to Demsico, it's the same. Demsico goes to Chrissy Colangelo under the will.
Regard to the 350.
350 is different, Your Honor. The 350, the $350,000 under the trust is different under the will. Under the will, I believe it was when the property that Demsico owned, gas station, was sold, the $350,000 would go to Christine Carlson. However, it's a pour-over will. The trust was in existence. We don't get to the will. And as we argued to the lower court, we believe that the will was really irrelevant here. You have a trust that's in existence. They're not challenging the existence of the trust. In effect, they're seeking to enforce, we believe, doing more than enforce it, but they're seeking to enforce the trust. So the trust is good. It stands.
What was the argument for the trustee not to turn over the house before this action? Years have passed. When did she transfer the house?
And I think that goes to the letter from counsel, including the release. And just for the record, Christine Carlson had been living in that house. She moved into the house.
I see that in the record, which makes it, one would wonder even more, why not turn over that house in terms of the title?
Well, she was willing to.
There's no argument that that is the decedent's wish, correct, and the grantor's wish.
The grantor's wish was that Christine Carlson would receive the house.
Right.
That's clear. However, in that letter from Allie Fisher, the attorney that was representing my client at the time, she explains that we're willing to give you the house, however.
Does the trust allow for that?
The trust
Put a
does.
contingency protecting and insulating
I-
the trustee from any litigation?
I believe the case law is clear that would be against public policy. But that's not what we have here. That language is not in.
So if that violated public policy, she's still not getting the house?
Well, no,
The position is she's not even getting the house.
But the lower court determined correctly
Yeah.
that the action of not giving her the house was trumped by her triggering the interorum clause. And I maintain that that was correct.
Well, would she have triggered the interim clause simply by claiming a breach of fiduciary duty on the part of the trustee?
A breach of fiduciary duty with regard to.
Sign this release, indemnify me, whatever, not relating specifically to any of the dispositions called for in Article 6 of the trust.
I don't believe that would have triggered the interorum clause. That probably goes more along the line of a proceeding specifically to enforce the provisions of the trust. Hypothetically, it would be, you're not giving me these, I want to move to enforce the trust.
Oh, I'm sorry. So then to be clear, what could she have done to assert her rights to the house, which you're not disputing she had rights to the house, and whatever claim she wanted to make regarding these $350,000 and Demsico, what could she have done and without violating the clause?
I believe she could have brought a proceeding to
Yes.
enforce the terms of the trust. But once she
In-
went
in-
after
sorry,
Demsico,
where? In
Where?
what court?
Where?
I most likely would have been in surrogate's court.
And if she's not in surrogate's court and she goes to another court to do exactly that, has she violated the interim clause?
I don't believe that that jurisdictionally that would be a violation.
So how is this not exactly what you've described?
Because she's going after Demsico, and that's what triggered the interorum clause. She gets A and B under
What's the
the.
distinction between the two? I must be missing it, but can you explain that?
She had no claim to Demsico. Christine Carlson was aware that she had no claim to Demsico. In fact, she made an argument in her complaint that she had been receiving distributions from Demsico. In fact, a $50,000 distribution at one point. So one would think, in discovery, she'd be able to produce a K-1 or some sort of document demonstrating that she had an interest. She
But
had no
that-
interest in this company
That,
and
to me, I
claimed it.
think is about the merits of her claim to have an interest in Demsico, right? What I was asking is, in response to Judge Rivera's question, which is, you were asked, how could she enforce a right that she had, and you laid out an option, and the question is, how is that different from what she did here? Not with respect to the merits.
The difference here is she went after something that she knew that she had no right in. I believe Judge Garcia.
You're saying that it's a losing claim, but I don't think that you're disagreeing about the procedural path that she took. Is that right?
Well, procedurally,
Okay. Let's assume someone has a valid claim. Okay. what can they do to enforce it without triggering an interim clause?
Then they would, but again, we have to look at the claim, and I'm not trying to dance around the question.
I'm asking you, though, just indulge me, okay?
Okay.
I appreciate that you are saying that you think that this claim has no merit. But let's assume a case where there is a claim that has merit. Perhaps you have a K-1, whatever might indicate some ownership interest, okay? What can that person do to enforce that ownership interest without triggering an interim clause?
I believe that they could bring a petition to enforce the trust in surrogate's court.
And that would not trigger the interim clause provided that they were successful?
Provided that they were not seeking something that they weren't entitled to under the trust.
I'm not sure if that's a semantical distinction or a substantive one. How is that different than saying they were successful or unsuccessful?
It's different because here, if she sought to enforce the trust by saying, I want the house, I want the money, and stop there, she receives those bequests. And granted, there's precatory language with regard to the $350,000, as we had taken that position in a pre-answer motion to dismiss. However, if she had asked for those two things, which she receives under the trust, entirely different than going after a company that goes to my client under the trust.
But in a case where, I know your red light is on,
Yeah.
but in a case where, again, indulge my hypothetical, where someone in fact has a valid claim to an ownership interest in a company, your view is that that would not trigger the interim clause?
Well,
Because like the 350, there would be a viable claim.
We would look to the language of the trust, and if she had if that claim or that bequest, if you will, was given to her under the trust and she sought to enforce it, and I don't think.
And you agree, I know your red light is on, you agree if she had not received anything else under the trust, nothing else, okay? She's not named at all in any shape or form, but she believes that she's got a 50% interest, that she could have sought to gain that interest in an action, because she's not violating the interim, she doesn't otherwise have any claim under that trust.
Well,
Saying when it says his interest is only 50%. She's saying, I'm a 50% owner, I want my 50%.
well, if she wasn't receiving anything else under the trust,
trust.
then she wouldn't
Because she's
be
not named.
she wouldn't be subject to the interim clause.
Correct, that's my point.
Yeah.
Yes, I just want to make
Yeah,
sure
yes.
we're all on the same,
Yes.
same page, but for the listing of the other things that you're not disputing she was entitled to, that she would have been able to challenge this.
And if I may, and I know the red light is on, but just to make clear for the record, the house, absolutely, she was entitled to, but I do want to make clear that the $350,000, we did maintain and did not abandon that argument that that was precatory language. The words in the trust were wish and desire. In our opinion, those were clear words of precatory import. So,
Thank you.
Thank you.
Counsel, can I ask you a question over here? Sorry.
Yes.
I just want to make sure I understand the sequence of the litigation. After your client commences this action, there's I think, a rather immediate dispute over ownership interests in Demsco, whereby she's claiming that she's a 50% owner of Demsco. And in 2021, I think Supreme Court issues an order stating that she, in fact, does not have a 50% interest in Demsco. And what I read the record as saying is that she continues to press that claim into subsequent years, into 2022, and that's the point at which it's determined that she's violated the interim clause by challenging the transfer of what is now not only all of the testator's ownership interest in Demsco, but what has now been determined to be a 100% ownership interest in Demsco. What's wrong about that?
With all due respect,
Yeah.
the procedural posture of that question is incorrect.
Okay.
And so she did bring an action with respect to Demsico. Once the Supreme Court said that she was not a member of Demsico, which I believe was May of 2021.
I agree.
we filed a notice of appeal, and we did not perfect that appeal. Why? Because the defendant's respondents, within a matter of 3 weeks, made another motion for summary judgment dismissing the complaint in its entirety. We filed a cross motion for summary judgment, and so yes, we actually abandoned that and did not perfect our appeal on the grounds that the court decided it, we believed incorrectly, because all Christine Carlson did was she had a personal interest in Demsico based upon her $100,000 investment, but we moved on. And
So
so
wouldn't that have been a better vehicle to do that at that juncture, to either ask for re-argument or appeal that portion of the Supreme Court order?
Your Honor, no, because the other summary judgment motion was already fully submitted, and we believed, given the costs of litigation and so forth, if we won our cross motion on the second summary judgment motion, the first issue with respect to Demsico would have been moved.
Counsel, it does seem like this is a case about litigation strategy and litigation risk. So there were possibilities of doing some things in surrogate's court. I do read the trust as being essentially just a pass-through, where these things are supposed to happen, 1, 2, 3. You could have sought to enforce 1, 2, 3, including 3 being the house. Once that was done, the trust is done, as I read it, and you could have said, okay, great, whoever's the owner of Demsico now, I own half. But you didn't do that.
Well, Your Honor, let's look at what we did do at the
We are.
outset. We attempted for 2.5 years to get a copy of the trust, and when we get the trustee's
I'm not saying that
letter.
the behavior here was good or bad.
Well,
I'm
wait.
saying you had choices, litigation choices in response to that. Different areas of litigation carry different types of risks.
Let me answer that 2 ways. Number one, what we first did was reached out to the attorney drafter, Allison Fisher, before litigation was commenced to say, let's sit down, let's talk. What did she do? She ignored Mr. Strang's emails, and she did not return calls, and said, sign this receipt, release, and indemnity.
And at that point, why don't you go to court and say, I want the trust enforced. I want the distributions made. Not saying what they should be, make them under the terms of the trust.
There, too, in that respect, and keep in mind all of this talking about SCPA 1404, EPTL 3-5.5 regarding construction, these relate to wills. And the courts say, well, they also relate to trusts. But there is a difference, as Judge Rivera pointed out. The trust was effective upon signature. And on day one, that house should have been transferred.
Let me go back to my question, though. Why, at that point, couldn't you just bring an action to force the distributions under the terms of the trust?
The answer to that is Singer tells us to look at the conduct. The conduct Christine Carlson believed, based upon her $100,000 investment in Demsico, that she had a good faith interest in Demsico.
When did you ever get a copy of the full trust agreement?
Your Honor, not until we commenced litigation.
So before you commenced litigation, you didn't have the instrument to assess?
They wouldn't give it to us. We had pages of the trust. So we had the interim clause, and we had Article 6. I just would point out also, so we didn't actually have the residuary of the trust. Another breach of the fiduciary's duty was what happened during those 2.5 years while Christine Carlson was patiently waiting. The trustee sold property and assets of the trust, distributed them to herself. There are so many violations of fiduciary duty that I'm sure Judge Cardozo, the author of Maynard versus Salmon, would recognize and hope that fiduciary duties mean something and that trustees cannot violate their fiduciary duties from day one and force beneficiaries.
Do you know of any case where a trustee violates public policy, in this case with the letter requesting
an
the
indemnity?
sign, right? Yes. And then uses the interim clause as a shield?
Well, keep in mind, interim clauses every case that you'll read and that's in these briefs is brought by a distributee, of which Christine Carlson and Chrissy Colangelo are not. But no, we have not found cases where, let me put it to you this way, that the cases that discuss this issue with respect to public policy, matter of Rimland, various cases say that when a trustee inserts a precondition to getting a bequest or seeks to exonerate their breaches of fiduciary duty as a precondition for a beneficiary to receive a bequest, those are without question void as against public policy.
Does that mean then all bets are off once the trustee does that? I could challenge anything under the trust because they've acted in violation of public policy in that way. So now I could say, you know what, I get all of Demsico because you've violated public policy. Is there a limit on what you can challenge after that once there's some violation of public policy?
Well, that would perhaps be in the discretion of the courts. However, what I would say is since there are no statutes governing trusts in this regard, only wills, that a fiduciary has to abide by their fiduciary duties.
And there are
Trustees cannot do
remedies for
this.
violating fiduciary duty, but is one of those
Yes, and
remedies...
that is to replace them. Oh, sorry.
Is one of those remedies, I can now challenge the trust on any basis?
I believe, Your Honor, that the first remedy would be to remove the trustee if she is violating or he is violating his fiduciary duties. However, and by the way, an action, and if you look at the Accoy case, a First Department case affirming Judge Maya's decision in the Surrogates Court, New York County, actions whereby you seek to hold trustees accountable do not violate interim clauses. So the first step would be to remove a trustee who, as Chrissy Colangelo
If the
did-
court holds against you on the appeal before us, does your client have any recourse to get a house, anything?
No. The house was sold, no. And so poor Christine Carlson,
The trustee sold the house.
yes,
Are there proceeds from the house that you
I
might
believe
be able
so,
to?
yes,
got
I
any
believe
action?
so.
You got any action to get that?
Yes. In fact, we're before the Supreme Court, Justice Ubel, on May 13th.
Okay, so you have
After this
some
honorable
recourse.
court
It's
decides.
not the house, but you have some recourse.
Money,
Money,
yes.
yes, okay.
Because otherwise, she's out of luck, and the decedent's intentions have not been honored. Thank you, Your Honor.
Thank you.